Yes, Mr. Alexander, I think we were going to look at the court in Peterson, weren't we?
Yes. Which is in the same tab, the same bundle at the next tab, 2 of 3 at tab 16.
Yes.
Now, it is, of course, true that the court didn't deal in the level of detail with the points that the Advocate General dealt with that I drawn your attention to. But in all submission, the general points that it made certainly, in some ways, clearly picking up on them and supporting them, and in other respects, certainly not contrary to them, and I'll come on to it.
Some paragraphs of the Advocate General's opinion they explicitly endorse.
Yes, absolutely. So if we could take it up at, for these purposes, paragraph 113. And going over to 118, if I can just make a few points on those. First of all, the court there acknowledges between F and G that the providers of the services concerned cannot, in accordance with Article 15 of that directive, be subject to a general obligation to monitor the information which they transmit or store, or to a general obligation actively to look for facts or circumstances indicating illegal activity. And I would invite my lords to underline that point, because we say that is an important aspect here, that if Article 14(1)(a) is to be given the effect that we submit it should be with respect to the requirements for knowledge, that is consistent with that approach. And where the learned judge departed from that was to suggest that there was an obligation on Samsung to look for facts or circumstances indicating illegal activity. In particular, that she thought that Samsung ought to have a detailed set of procedures in place for looking to see whether or not there was illegal activity. Indeed, that's the program of activities that were set out in the judge's paragraph 226. And we respectfully submit that that comes into conflict with the approach in Peterson. Now, it is said, I think, in my learned friend Skeletons, I should deal with it now, that this is not formally retained law, and that's true, because it's a decision, I think, after
Yes, it is. Yes, yes,
the relevant,
it's after
relevant date. But we would submit that it is highly persuasive, because this purports to be an interpretation of the earlier law, not a change in, it doesn't reflect a change in the law. What it is doing is essentially saying this is what the consequences are of this provision.
So your submission, I think, is this, isn't it? You don't challenge a judge's findings of primary facts, that as a result of your content review, you knew what the design looked like and you knew the name of the developer.
Correct.
But you say, unless you can say that it would have been apparent with those two pieces of information only that there was unlawful activity going on, you weren't required to do any more.
That is, well, it's not that we were not required to do any more. We were obviously required, if we were sent an invalid notice.
Leaving aside, take notice to take
with,
down, but at the pre-screening stage
phase, we weren't obliged to do more. Secondly, in that paragraph, pursuant to Article 14(1)(b), actually like the point that I was making, those providers must, as soon as they actually obtain knowledge or awareness of illegal information, act expeditiously to remove or disable access to that information. and must do so with due regard to the principle of freedom of expression, but that it's only in relation to specific content that such a provider is able to fulfill that obligation. And that reflects the point that a rights owner is in the best position to draw attention to specific content that may be affected by a right, and that the service provider is obliged to act with respect to that content and not more generally. The court then goes on to say the fact that the operator online content sharing platform automatically indexes content uploaded, the platform has a search function that recommends videos on the basis of user profiles or preferences, is not a sufficient ground for the conclusion that the operator has specific knowledge of illegal activities carried out on that platform or illegal information stored on it. And again, that is an important point, because what that is saying is that the fact that there is that kind of approach to content indexing, that it has a ability, the platform has an ability to search for content, which if the platform has an ability or gives users an ability to search for it, also gives the platform itself an ability to search for, as it were, its own content on its own platform, and that it recommends videos on the basis of users' profiles or preferences, so on the basis of material that's supplied to the platform by users or otherwise, is not a sufficient ground for the conclusion the operator has specific knowledge of illegal activities. Next point in paragraph 115 regards more specifically the second of the situations. The point in issue in this case, awareness of facts or circumstances from which the illegal activity or information is apparent. Court has held that it's sufficient the service provider concerned has become aware, one way or another, facts or circumstances on the basis of which a diligent economic operator should have identified the illegality of the question and act in accordance with 114(1)(b). And then this, but the court goes on, and it's important to read what the court had in mind there. That includes, into really, the situation which such a provider uncovers as a result of investigation undertaken on its own initiative, an illegal activity or illegal information, as well as a situation in which the operator is notified of the existence of such an activity or such information. But it goes on, in the second case, although such a notification admittedly cannot automatically preclude the exemption from liability, given that notification of allegedly illegal activities or information may turn out to be insufficiently precise or inadequately substantiated, the fact remains that such notification represents, as a general rule, a factor which the National Court must take account when determining, in the light of the information so transmitted to such a provider, whether the latter was actually aware of facts or circumstances, and so forth. And our submission on that is that even in the case of an express notification by a rights owner, that of itself does not necessarily give the service provider notice of illegality. It may, as the court recognized, be insufficiently precise or inadequately substantiated. And if I may just come back to the example put to me by my Lord Justice Arnold of the, as it were, slam dunk mark for sign 10.1 infringement. And it's an example in this case because subsequent to the proceedings, there have been revocation proceedings in relation to the some of the marks in issue. And some of the marks have been revoked for non-use, including in relation to parts of the specification where there was a finding of infringement. Now, I don't make that point for particular reasons related to this case, but what it shows is that even if there may be a prima facie case of similarity of mark for sign, it doesn't follow that there's actually a right that's infringed. Take, for example, even something like the mark McDonald's. It may be that it is perfectly validly registered for restaurant services and food services and associated services. But it doesn't follow that any use of that sign in any context would be regarded as an infringement. For example, if it was used to refer to the character and quality of the goods, if it was used in a certain comparative advertising, and so on. So this issue of mark for sign, when one is dealing with content, which may not be, as it were, straightforwardly trademark content. When I say straightforwardly, where there's someone who uses a trademark specifically for designating the origin of goods, the primary case for trademark infringement.
Sorry, can we get a little closer to the facts of the present case? In the present case, your clients were aware that there was dial, what the judge calls dial branding. It's obvious trademark use. So isn't that a factor to be taken into account?
Well, we would respectfully submit that that is not obvious trademark use. It may be held to be in some contexts. What there was trademark use, certainly in relation to the apps, and there is a point of debate as to whether it's use in relation to dials.
Yes, but you accept its use in relation to the apps.
Indeed. I mean, having gone through the whole trial process, we're not challenging that. Yeah. But my point is not. My point is the reason I put this point not on the basis of the facts of this case, but with one aspect where there's an illustration here, is because if the court is interpreting this law as it applies in generality.
But this is the problem I keep on coming back to, because you constantly try to argue this case on the basis of copyrights and patents, whereas this is a trademark case.
Indeed.
And one of the key facts of the case is that what we're talking about is faces for watches with brands in the dial branding position. So anybody who is aware of the context will see immediately that there's a potential trademark issue. And if you dispute that, why do you dispute that?
Well, for the same reason, or similar reason, that a person seeing a design that reproduces a design of, let's say, one of the claimants here, would not automatically say there is an issue. They might say it's possible that copyright or it may subsist. It's possible that this mark may be validly registered in relation to, in the case of the trademark, it may be validly registered in relation to some goods and not others. It may give rise to a reason to investigate if one were doing a full rights searching program. But this issue of whether there is use in relation to goods, which I'll come on to, is not always clear-cut. My lord will remember the case Trebor-Bassett, where the question was whether or not a mark appearing on cards, this was a case concerning football cards, where the Football Association's trademark appeared on players that were then on cards. So the mark was physically on the cards, and they were used as decoration, whether that was trademark use at all. And ultimately the court there held, well, it's not trademark use, albeit under an earlier statute. My point is only that if one's looking at something that is not a paradigm of trademark use, any more than it would be to have the mark McDonald's on a face of a watch, or the archers. And I'm not taking that as a particular example because I don't want to say that would or would not be. But where one's dealing with what might be called decorative use, it's certainly not clear that something is going to be an infringement under given law in given contexts. It may be clear that if one was doing a rights management program, that is something one would want to investigate. And that is why, in my respectful submission, even focusing on the narrow context of trademarks, this passage in the judgment of the court is really very relevant, because it's not suggesting that there should be a exploration that one's got to go to one's lawyers and say, well, actually, if you have this kind of thing on your as part of a declaration that is produced by an app, it thereafter automatically becomes trademark use, which gives rise to actionability.
What do you say about the court's use of the word should twice in that paragraph?
Yes.
You've emphasised the word would in your
Yes.
skeleton argument. The court here says should.
Yes, your lordship is absolutely right. On the basis of which a diligent economic operator should have identified the illegality in question. But the following paragraph the following sentence is of critical importance to see what's meant by that. It's not that the diligent economic operator should have gone out to look for facts which would have identified the illegality. What that includes is situations in which facts have come to the diligent operator's attention, which, having come to its attention, would have alerted the diligent economic operator to the issue. And we respectfully submit that that is clear from what's said. It includes the situation in which a provider uncovers, as a result of an investigation undertaken on its own initiative, an illegal activity or illegal information, as well as a situation in which the operator is notified of the existence of such an activity or such information. That is what the court is getting at. It's not getting at a situation that is suggesting that there should be an active inquiry.
So you say uncovers means actually uncovers, not could have or should have.
Absolutely. Well, there's no suggestion here that what it means is could have uncovered or might have uncovered in other circumstances, or even would have uncovered had it been more diligent. This is all about information which is in the possession of the diligent economic operator, not about information that the operator could obtain through other means. And if anything, that is confirmed by paragraph 116, where it said in that context, it should be observed that a notification that protected content has been illegally communicated to the public via a video sharing platform or a file hosting and sharing platform must contain sufficient information to enable the operator of that platform to satisfy itself without a detailed legal examination that the communication is illegal and that removing that content is compatible with freedom of expression. So it has got to be immediately apparent, is the term apparent, which is part of the legislation. It's got to be apparent, leave aside immediately, that the communication is illegal. Not might be illegal, raises a question that I need to raise with trademark lawyers in every country of Europe or elsewhere, is illegal. And I mean, if one wants to go into the details of this in relation to other rights, one can. I think I've said enough about that. But even in relation to trademarks, we submit that the obligation is not one to go and look and do a rights evaluation exercise. It involves detailed legal examination. And the final point in that paragraph, Article 14A must be interpreted as meaning that for such an operator to be excluded under that provision from exemption of liability, it must have knowledge or awareness of specific illegal acts committed by its users relating to protected content that was uploaded to its platform. So it's not a question of some general knowledge of illegality, it's a question of knowledge of specific illegal acts. And we respectfully submit that that is not the approach that was taken by the judge, if I can come back to that at the end. Before I do that, and I'll perhaps come back in answering any points on Article 14.1 and other points in Peterson, I think I've outlined our position in relation to that. can I go finally to one recent piece of legislation on this issue, which is referred to in my learned friend's skeleton, and is in some senses helpful to see where how the battle lines are drawn and how the...
Can we be clear as to the status of this? I mean, the 2018 Act tells us that we may have regard to subsequent case law of the Court of Justice. Where does it tell us to have regard to subsequent EU legislation?
Well, it doesn't say...
Might be regarded as constitutionally questionable for courts in this country, after we've left the EU, to be guided by post-Brexit EU legislation.
Yes, you are right, but equally it might be. My submission is in a sense no higher than this. That even if one takes that legislation as having no greater authority than, let us say, an academic article written in relation to what the legislation in question, so the pre-Brexit legislation, means, it is not illegitimate to refer to it. I'm not going to submit that this court is bound by it, not least because the passages that I want to refer to come from recitals, and what they effectively amount to saying is that they are clarifying a position under Article 14.1, that the act of undertaking activities where there is search to identify illegal content doesn't take the operator outside the provisions of the law. And you can look at that either way. You can either say, well, this is law that changes the law, but the way in which the directive or that regulation suggests that the position has developed is that it's a clarification of the existing position. And so, I mean, I'm quite happy to leave that there for the time being. It's my learned friend who's raised it in connection with Article 14.1. Because
yeah, well, the same question will go to him.
I accept that, and I'll leave that there for the time being. But my point is that the approach that's taken to
since you've raised the question, which recital do you want us to look at?
the recitals are 18 to 26, and in particular 26.
This is the Digital Services Act.
On Digital Services Regulation, and they are at pages 66 to 67. And the relevant provisions are Article 7 and Article 6, which are on JA 105. And the question there really is whether Article 7 is clarifying the position under the directive that we're looking at, or whether it is making a fundamental change. And in all respectful submission, what is suggested by the recitals is that there is a clarification. In fact, the providers don't.
On the other hand, it is undoubtedly a substantive provision which was not in the e-commerce directive.
Oh, yes.
And one can always ask the question, why did the legislature feel necessary to put it in?
Oh, that was the point that I made, which is the counter to the point, and you know, my lords will need to consider the impact of that. But in our submission, the way in which that's described in the recital, and that's why I was going to the recital, was that the legislature did not, in our submission, consider that it was making a change to the law, but more a clarification of the law. And my lord may say, well, that is something that is constitutionally impermissible to look at, but even if it is only regarded as an academic authority, or having the same weight as an academic authority, it is not of no weight. And in particular, it is consistent with the approach to the paradox that the Advocate General drew attention to in the Peterson case, and which, in our respectful submission, although the court did not expressly deal with, nor did it suggest that that was something that was inappropriate. So, if I may come back to that, if needed in response, I hope I've articulated our position on the Article 14.1 point sufficiently for present purposes. And may I then close this aspect of the case, the Article 14 point, just by going to the judge's judgment to identify the points where we take issue with. She deals with this aspect from paragraphs 222 on to 229. That's core bundle 139. And she proceeds on the assumption, essentially, that Article 14.1 is in principle applicable for the reasons that we've articulated sufficiently. And in 222 says she prefers to base her conclusion on Article 14.1a. And she says she can't accept our submission. The condition is not met unless, as long as an app store provider does not design the relevant app or make any sort of changes to it. It's clear that whether the test is one of whether a diligent economic operator should have identified the illegality by reference to facts or circumstances of which it is actually aware. The existence of notice and takedown procedures does not of itself provide a defence. And our first point is that she should have said, if there is a valid and effective notice and takedown procedure, that will be sufficient for the reasons I've given in extenso. Second, insofar as she dealt with the content review, she held that it would have resulted in the reviewer, and through it Samsung, becoming aware of the app name and the appearance of the watch face, including any dial branding on it. And for present purposes, we do not disagree with that. And she noted the modifications that had been made to improve the system. But then she said in paragraph 225, in the case of those apps I found did infringe, I've concluded that the awareness of the app name were relevant and or the appearance of the watch face, and specifically any dial branding on it that would have been gained during the content review process, would have alerted a diligent economic operator to the infringement. And our point is that there is something missing there, namely knowledge of the rights and how they affected the products. And one can tell that that was missing because essentially her view in paragraph 226 was that Samsung should have equipped itself with knowledge of the rights. That was the whole point of the passage that I've drawn my Lord's attention to. And we respectfully submit that that was not the right approach to this legislation. There is no obligation under the legislation in order to take advantage of the defence to do acts set out in 226 or any acts like it. If searching had been undertaken and facts had come to the attention which would have given rise to these issues, then of course the position would be different. But that is to strike the balance in a way that the legislation does not strike the balance in our submission. And so we respectfully submit that this approach to Article 14a was not what the directive requires, and that what the judge should have said is something like, first, the fact that Samsung operated an effective notice and takedown procedure when it was alerted to these rights satisfied the requirements of Article 14.1a insofar as it was required to act with due diligence, and insofar as it undertook a content review, it was not obliged to go further to seek out rights of which it was not then aware in order to be able to determine whether or not there was illegality.
Can I ask how far you go with the question of lack of awareness? And I'm going to put a question that may seem strange, but I think the purpose will immediately be apparent. Do you dispute your clients were aware that watches, generally speaking, bear trademarks. And those trademarks are, generally speaking, protected by registrations.
I doubt that they would dispute that. No.
Right. So what is the missing knowledge?
The missing knowledge is of the relevant rights. One can't simply say someone knows in general that there are rights which might affect a product. It is true that doubtless everyone knows that certain kind of content may be protected by all sorts of rights. It's true.
But there's a difference between a theoretical appreciation that intellectual property rights may exist and knowing that the specific product is trademark, bears trademarks, and those trademarks are registered. So what I'm trying to ascertain is what you say the missing knowledge is. Is it the specific registration? So in other words, you say they have to know the number of the registration?
Well, they have what someone would have to know in order to be to have the relevant specific knowledge of infringement is the trademark in question as registered, the territory.
So the number, you're saying they need to know the registration number?
Yes, I mean the registration.
So basically your submission is they need to know everything that's on the register. They need to know the number, they need to know the form of the mark as registered, they need to know the specification of goods and services.
Yes, and I mean your lordship has correctly identified the three key characteristics of a trademark.
Yeah.
And it's not it's not unreasonable, one might say, to expect proprietors to alert undertakings to those rights if there is a potential concern about this issue, and even say, please look out for these. There was nothing of that kind in this case, and in our respectful submission, where one's dealing with international companies, global brands who maybe not have their either home country in Europe or home language, even in it being a European language, but where those products may be sold in other countries. If there is a concern about a category of products, for example, that might potentially have this issue, it doesn't strike the balance in an inappropriate way.
So
suppose the right owners should alert people to that.
Suppose that the app in question is for ordering burgers, and it has McDonald's on it. So I take it your clients wouldn't dispute that they know that McDonald's is a fairly well-known supplier of burgers.
Well,
but they would say, well, we don't know the registration numbers.
No, I don't think one has to be quite as extreme in the case of needing to know the number. And part of the reason I say,
So that was one of the things.
well, I thought that what my lord had in mind was that the number was a key to identifying the characteristics of the registration.
If you know the number, you can find everything else.
That's what I mean. I'm not saying one needs to know the trademark number, but what one needs to know is the identity of the sign and the goods or services for which it's registered. And my lord is of course right to say that the trademark number will give one those two. I'm not obviously saying that someone needs to know that it's 295 or whatever the actual numerical issue.
How do you know what the specification of goods and services unless you look?
Well, you might need to, and it certainly depends on what the app may be for, because my lord has put to me an example, an app for the delivery of burger services.
Exactly.
And you might say, well, it's a slightly odd example because, of course, McDonald's was one of the marks that was actually specifically identified as a famous mark in the content review. And I might say, well, if one knows that and it's an app for burger services, then that would be something that was that gave sufficient specific knowledge of illegality. On the other hand, let us take take a different example. Let's suppose that someone does a game, and the game involves, just sort of thinking on my feet, delivery. A sort of version of Monopoly or something like that, but delivering goods from various places. And someone uses McDonald's, Burger King, and whoever it is, the brand owners, as sites, in the same way that Monopoly uses Liverpool Street Station and so forth. So something that is, I doesn't want to make fun of it, but a kind of a bit of fun for users. I don't know whether McDonald's would object to that. They may have the mark registered in respect of games. They may have it registered in respect of electronic apps. They may say that that would be an infringement in that context, even if it was very clearly an infringement in the context of a burger app. Equally, I mean, let's take another example from the case, from the cases. Suppose you have a game involving rival taxi firms, and you have one that's named Uber and one that's named, I don't know what all the other ones are, some black cab firm. And it's possible, for all one knows, that Uber may have a registration for those kinds of things. Now, equally, it's possible that one might search for them. One might say, well, I don't want anything to do with that on the site. There are a whole lot of examples along those lines, and this goes back to my Lord's point. So, well, it's absolutely obvious that this is going to create an issue because it's dial branding and so on. Well, yes, that would, in some senses, be branding of an aspect of a game, but in circumstances where no user of the game would ever think they had anything to do with McDonald's or Uber in the examples that I've given. Or they might think, well, possibly it might have been licensed. It's very difficult to know, but the point I'm making is that even where there is use of the mark in the sense that the mark is reproduced somewhere in the content, it does not follow automatically from that should be regarded as use of the mark.
I was going to ask you about license. Do you say that the diligent operator has to be aware of lack of license? Lack of consent, I should say.
Well, there may be, that's actually a very good question. There may be some circumstances in which, yes, they would need to be aware of lack of consent. But let's take this situation. Let's take my board game situation, where someone looking at it might say, "Oh, I don't like the appearance of the McDonald's yellow arches," whether for trademark reasons or copyright reasons or whatever. But then they take another look at it and they say, "Well, actually, this looks like a game that's had relevant licenses in relation to it, prima facie." That may satisfy the diligent economic operator. Or they may say, well, I look at this and think it's likely that, or at least it's possible that an app developer has obtained relevant rights or has worked out that those rights are not relevant to what it's doing for whatever reason. Because bear in mind, it's not just us who are in the frame, it's the app developers who are developing these products. All of these require a degree of specific investigation, but our overriding point is that there shouldn't be an obligation to go and investigate. If a rights owner comes along and says, this is being used by an app developer, this is our trademark in relation to these goods, it's prima facie validly registered in respect of goods that would have a reasonable scope of catching, and they don't have a license, which may be implicit from the fact that they're writing in those circumstances, then the site may have adequate notice to exercise the takedown procedure. But until they have that kind of information? We respectfully submit that they don't. And so there was a lacuna in knowledge identified, or the required knowledge identified in the judge's judgment, and it's that to which we draw attention.
Now, have you dealt with the question whether Article 14 applies in principle?
I haven't completely dealt with that. What I was going to do was, I've opened it in general terms.
Yes.
If it would be convenient to just come back on those points briefly in reply. I think I've said enough to lay the ground, and then I can just pick those up. So unless I can assist your lordships further on that aspect, I was going to move on to the other trademark grounds and deal with those somewhat more briskly.
We're doing use next, are we?
Well, both of the points involve use. The first
And in relation to.
The first point involves use by whom?
Yes.
In particular, use by Samsung. And the second point involves use in relation to what?
Yes.
And I was going to propose to deal with those in that order. So the case law, as your lordships are well, my lady is well aware, that is developed in this area is the concept of the undertaking making use of its own commercial communication, and the distinction there being between allowing a third party to make use of facilities provided to supply and promote their own products, and to make use of the facilities it provides to promote them, and making the products in a very real sense their own products, and making it appear as though they come from them, or they are in some way connected with them. Now, the court, in all respectful submission, needs to bear in mind a few points on context on app stores. First, as the judge held, that the SGA mainly featured third-party apps. A substantial majority of the apps available in the store were developed and provided by third-party app developers. And the judge recorded that Samsung's evidence was that this was typical of businesses operating in the electronics industry, and that's at paragraph 46 of the judgment. Equally, she held that while it is true that a customer would not necessarily be familiar with this, or invariably have a clear understanding of the detailed contents of an app store, such as the number or proportion of apps that were third party, we respectfully submit that it is reasonable to expect that the notional average consumer, which ought to have been the addressee of this issue, would come to such a store expecting that a significant number, at least, were third-party apps, because that is the normal thing. And in a context of this kind, we submit that it's reasonable to work on the basis that the average consumer knows that which is, in fact, the case. It's not always the case to take that as an assumption, but it's such a matter in a sense of common currency that is a reasonable approach. Third, as with any app, and indeed many products which are designed to be used on or with other products, there will be a need to have some element of involvement of an app store platform provider. That's not only the case with an app store. Physical online platform may also have some form of involvement with products that may appear on the store. Indeed, for the very reasons that we've been debating in Article 14, to ensure that inappropriate content, for various reasons, does not appear. And that there is no reason to suppose that consumers would think that just because there may need to be, or may actually be, some process of interaction between store and third-party supplier, that the products are thereby connected in the course of trade with them, or to be regarded as their own commercial communication. The issue that we take with the judge's approach is that instead of looking at the uses in question in what has in some contexts been described as their local context, what the judge did was took a very overall view of Samsung's business model and conduct as a whole, including matters that were very unlikely to have any bearing on the actual uses of the sign in their context, and which would either not be known to the average consumer or would be very unlikely to be known. And in our submission, that was not the right approach. I could then turn to the law on this, which I think, well, we would submit can be taken largely from our skeleton, but it's worth looking at what is said in L'Oreal and in Coty in particular. In our submission,
just before you get into the details, what is your position on Lewison and Amazon? Because you've been relying very heavily on a post-Brexit judgment of the Court of Justice with regard to Article 14,
yes,
which you say is persuasive, and I understand why. Would you dispute the proposition that Lewison is equally persuasive on this question?
no, I wouldn't. And since my lord raises it, can I deal with that directly and up front? Because in a sense, it's the latest word on this, and it provides some assistance, albeit in a rather particular context, for dealing with this question. So, in some sense, it's jumping ahead, but because it's
take out of your orders. It's just that it wasn't one of the ones you mentioned. So hence.
No, you're right. It was the next point on my note, actually. But I think it's actually quite.
Go in order.
Let's take this. Let's take this in order. Can I take it first from L'Oreal and eBay, which is in tab 21. Tab 20. And the starting point is the discussion of paragraph 98 on J758.
Sorry, which page on?
It's 758.
Yes.
And that sets out the general proposition. It starts at paragraph 98 of the judgment, where the 8th question, the court is asking how the display on the website of the operator signs identical to be regarded in the light of the trademarks legislation. The court starts at the point that where sales are made through online marketplaces, the service provided by the operator includes the display for its customer sellers of offers for sale originating from the latter. So that's the starting point. Next, when such offers relate to trademark goods, signs identical with or similar to those goods will inevitably be displayed on the website of the operator or the online marketplace, so that those facts alone in relation to display are not regarded as sufficient to give rise to operator liability as such. And the question really for the court in a case of this kind is how one should decide how operator liability should be established. and what the approach is that should be taken to operator liability when the site is used by others to sell their own or supply their own products. And our submission is that the court then goes on to say that although it's true that in those circumstances those signs are used on that site, it's nonetheless not evident that it's the operator of the online marketplace that is using them. So that's the distinction that's been drawn, we say quite rationally, between use of the mark by the operator and use of the mark by the person using the operator's site.
When one gets to 105, the answer appears to be a blanket one, but we know from Lewison that actually the answer is not as blanket as that suggests.
Well, that's what I was going to come on to, actually.
Yeah.
I'm sorry to lay the ground like this, but
no, it's
my lord
important
rightly
to
said that
see where we were at that stage.
That not everyone may be quite as far ahead on.
Quite so.
And it seems appropriate that. So the next point is related to the one that I just made in 102. If the sign identical with or similar to the proprietor's trademark is to be used, that implies at the very least that the third party uses the sign in its own commercial communication, as well as the third party provides a service consisting in enabling its customers to display on its website in the course of their commercial activities, such as offer for sale, does not itself use those signs within the meaning of that EU legislation, and that's a consequence of Google. Then there's a reference to the United Kingdom government and the Commission, pointing out that it follows the use of the sign identical with or similar to trademarks offers for sale displayed in online marketplaces made by the sellers who are the customers of the operator of that marketplace and not by the operator itself. However, inasmuch as it enables that use to be made by its customers, the role of the online marketplace operator cannot be assessed under the directive, but must be examined from the perspective of other rules of law. And then coming to the point that my lord made, view of the foregoing, the answer to the eighth question, the operator of an online marketplace does not use, for the purpose of Article 5 of the directive, signs identical with or similar to trademarks which appear in offers for sale displayed on its site. Now, that is as far as it goes in the L'Oreal case. And as my lord observed, because things were resolved amicably between the parties, your lordship, I think it would be fair to say, was deprived of an opportunity to
It's always better when parties resolve their disputes for themselves.
I did not say an opportunity that your lordship would have relished, but an opportunity nonetheless to take the decision of the European Court and develop your own thinking in relation to that. But that's why we don't have a return application of these principles in the L'Oreal and eBay case. But that is the overall picture presented in our respectful submission by the law. Now, it's perhaps at this point that actually it's useful to come to Louboutin itself. Coty is a slightly different case because it's really a warehouse or physical goods warehouse case. So if I can come to Louboutin, which is at the next tab but one, so JA 799. Which again is a case relatively recent and not one that the judge could have taken into account. Now, our submission is that overall, the conclusion in Louboutin supports two core propositions. I'm sorry, the conclusion and the reasoning. First, that this is a question to be looked at predominantly, and I will qualify or come on to any issues on circumstances where there may be a slight variation, predominantly from the perspective of the notional average consumer. And that comes inter alia from paragraph 48 of Lewison, Joint Authorities 808. And the proposition is that the advertisement may establish a link between the services offered by that operator and the sign in question on the ground that a well-informed and reasonably observant user might believe that the operator is marketing in its own name and on its own account the goods for which the sign in question is being used. And that concept of the reasonably well-informed, reasonably observant user is picked up again in paragraph 50. As to whether or not the goods are presented in a way which enables a well-informed and reasonably observant user to distinguish easily between offers originating on the one hand from the operator of the website, on the other from third-party sellers active on the online marketplace which is incorporated therein. And that again is said to be a consequence of L'Oreal, with which obviously one can see exactly where that comes from in L'Oreal. And then there's reference to factors that might be taken into account in paragraph 52, particularly where the operator of an online sales website describes the various offerings from itself or third party without distinguishing them as to origin as best sellers or most sought after or most popular for purposes entirely of promoting. That presentation is likely to strengthen the impression that they're being marketed by the operator in its own name and on its own behalf. And second, the nature and scope of the services provided by the operator, such as services including inter alia dealing with questions of users relating to those goods, the storage and shipping and management of returns, also likely to give the impression to a well-informed, reasonably observed user that those goods are being marketed by the operator in its own name and on its behalf, and may thus establish a link. And then the overall conclusion was given in paragraph 54 on that, and picking up on some of those points, but the core point being whether or not a well-informed and reasonably observant user establishes a link between the services of the operator and the sign in issue, which is in particular the case in certain circumstances. Now, in our submission, that general proposition of law does not depart from the L'Oreal line of case law. What it indicates is certain circumstances which may be taken into account, but equally, it doesn't suggest that one should not look at matters from the perspective of a reasonably informed, well-informed and reasonably observant user in order to determine whether or not such a user would think that the products in question, in this case apps, were third-party apps or whether they were Samsung
before we
apps.
get on to the facts of the present case, and I don't think it's at variance with what you're submitting, but would you agree with this way of looking at it? That what the court is here emphasising is, as you say, you look at it from the perspective of the average consumer. But what the court is emphasising is that it's a question of how it is presented. That is to say, when you look at the use of the sign complained of in context, how the context presents that use.
Yes, I think there are. Sorry, in my submission there are two aspects to that. One is how the context presents that use, but the other is also what.
Sorry, you said how the context
I'm sorry, how context
presents the sign. The use, you said, but did you mean the sign?
I said use. That was I missaid. How the context presents the product on which the sign is used. And I accept the proposition put to me by my Lord Justice Arnold on that.
Well,
But
I'm not sure it is a question of how it presents the product. It's how the sign is presented in the context. Because we know there's a product being sold or goods being supplied, it doesn't matter. The question is one of presentation, and specifically the presentation of the sign, because it's the use of the sign that is alleged to be infringing. And the question is, by whom is the use being undertaken? And fundamental to that assessment is how it's presented.
my Lord is of course right. The only reason that I was framing the question in the way that I did was that the Court of Justice refers to whether the user has the impression that the operator itself is marketing in its own name and on its own account the goods bearing that sign. And that's why...
But see, this is what we get out of paragraph 51.
Yes, and 54.
Where the point is being made, and we know what they're talking about. They're talking about Amazon, where certainly at the relevant time, you got all the different business models being mixed in together. So sometimes it was Amazon selling its own goods, sometimes it was Amazon selling third-party goods with Amazon fulfilling, sometimes it was Amazon selling third-party goods with the third party fulfilling. And the notional average consumer couldn't tell the difference. And that's what I mean by presentation.
My Lord is absolutely right, and I don't think we're disagreeing on this. The only point that I just wanted to pick up on was that my Lord was referring to presentation of the sign, and I referred to presentation of the goods bearing the sign, which seemed to be more in tune with what the...
But it's an advertisement.
Yes, your lordship is right. It's an advertisement for goods.
Yeah, and it offers for sale and so
and offers for sale and so forth, which may bear the mark. Without getting into too much of fineness of grain between offers for sale and advertisements for this purpose, which doesn't matter here, the issue is whether or not the relevant consumer would have that perception, and it's a perception, as it were, at point of encounter, rather than looking at the whole business model of the undertaking. My Lord has, of course, rightly observed that in the Louboutin case, one of the reasons why the court made the findings it did in that context was because the Amazon companies had these different business models. But it was not suggested in that case that the reason for the way in which the judgment was phrased was because the consumer was assumed to know details about Amazon's background, commercial purposes, and so forth.
On the contrary, the assumption was they didn't know.
That's my point. They didn't know that, and Amazon's overall historical reasons for putting the marks in this, or putting goods in this way, were not regarded as relevant for the purposes of determining whether or not this was the commercial communication of Amazon. And the reason I make that point is that the place where we differ with respect from the judge is the judge was looking at a whole lot of background factors concerning Samsung's business model, its approach to these apps, and so forth, and was not looking at the fact that an average consumer in this context would be approaching the Samsung store with a knowledge, albeit not a detailed knowledge, that third-party goods were expected, third-party apps were to be found on an app store, which we respectfully submit is absolutely standard knowledge, even if without detail. And that the natural assumption would be that these were apps that were third-party apps, an assumption that would need, in some sense, to be specifically displaced before an average consumer would regard there as having been Samsung's communication of these apps, they being Samsung's apps rather than supplied by Samsung on its own account. And so this issue relates to two aspects. First of all, the factors that should be taken into account in determining commercial communication. And secondly, how one should approach the, well, I don't like taking concepts from other areas of law because I sense it doesn't go down very well, but the mindset, if I may use that term, of the average consumer, namely, or the common general knowledge, use an even more patenty term, of the average consumer, that which someone would be naturally come with, even if they wouldn't know the whole detail. So our submission on this is that if one looks to how the judge addressed this issue, her points on this just went too broad, and that if she had been focused on the points that she ought to have been focused on, bearing in mind the approach that an average consumer should be assumed to take, she would have said, well, actually, the consumers would have realized that these were apps that were third-party apps, they were not Samsung apps, and Samsung ought not to be regarded as having made commercial communication with respect to those, even though it was the platform, obviously, upon which those third-party apps appeared. So the point in the judgment to take it up is at paragraph 95, and that goes on to 110.
Just before we go on to the judge's discussion, the Labutin case concerned 92A.
Yes.
Is the concept of use by someone the same for B and C?
Yes, I can't think of a reason at the moment why it wouldn't be.
Well, because the judge found that the average consumer would perceive a link between Samsung and the trademark proprietors, in the sense that they might think these were officially licensed or something like that.
Yes.
You say this question of use comes at an earlier stage, do you?
We say it comes at an earlier stage. I mean, that's part of the reason why I'm hesitating in answering my lord, because there are a number of points where links of various kinds might be made.
Yes.
Our submission is perhaps a more fundamental one than that, which is that the factors that the judge took primarily into account were factors that were not, as it were, average consumer factors, and that had she done the evaluation from the right perspective, namely that of someone who is assumed to know about app stores, even if not in detail, then the natural assumption that you would come to with this store is that this wasn't Samsung's apps in relation to the specific apps in question, but that these were third-party apps, and that there wasn't any particular reason to think that there was any relationship between Samsung and the apps, or at least none that went beyond what the necessary relationship would be in order for apps to be on an app store at all.
So even if the average consumer might have thought that Swatch had licensed some developer to produce these faces, you say that still wouldn't be used by Samsung?
No, that's exactly the point. Indeed, if a consumer thought this is a third-party app and it is an app which will produce a image of this kind, the natural reaction in our submission of an average consumer armed with that, as it were, the notional knowledge, would be, if they thought that there was any link between the brand owners and anyone, it would be a link between the brand owner and the producer of the app, not a link between the brand owner and Samsung. Just as if one sees an app on a phone ordinarily, and you think, or in any app store, which has content, let's say, well, let's take one of the examples in the case, Super Mario, or one of the cartoon characters. There's no reason to assume that the app store and the proprietors of the relevant IP rights have some kind of relationship one with the other. There would be some reason to think that the app designer might, or there might be, had a relationship with the proprietor of the rights. So insofar as there was any link in question, it was just not reflective of that aspect. But does that answer my?
Yes, it does.
Enough?
It does lead to another question, though. Is this all a question of fact for the judge?
Well, there are two points on that. First, the issue of approach, namely what factors are properly to be taken into account in determining whether or not there is use by an undertaking, is not only a question of fact for the judge. In particular, if this court came to the conclusion that the judge had taken into account factors that the judge should not have taken into account in determining whether or not there was a commercial communication, then it would be perfectly open for this court to say that that evaluation by the judge was incorrect as a matter of law, because it had been undertaken on an incorrect approach. The second aspect relates to the characteristics of an average consumer. Now, I accept that that is somewhat more sort of on the factual end of the spectrum, but the thing about an average consumer is that an average consumer is not a real person. It is a notional person.
Not really. The current state of the case law is that the average consumer is a proxy for the body of consumers, excluding those who are either insufficiently knowledgeable or too knowledgeable, insufficiently careful or too careful. So we exclude the ends of the distribution,
yes,
but otherwise we're looking at everybody on the curve.
and I accept that, but my point is that it's not as it were a representative of any given individual actual consumer.
Certainly not. No.
And so the question then is what approach this court can or should take to an evaluation of an average consumer looking at this material. But we respectfully submit that if the judge made the had the issues of approach that we've identified, then this becomes open for re-evaluation more generally in our submission. And our case is that in paragraphs 95 to 110, she took factors into account which were not relevant factors in deciding whether or not this was Samsung's commercial communication as presented to the average consumer. So if I can just go through those.
Well, can we, sorry, just before we get there, the judge sets out her assessment of the average consumer at paragraph 81.
Yes.
So what, if anything, do you say is wrong with that?
We don't say there's anything wrong with that, but it's important to understand what the judge was saying and what the judge was not saying in relation to that, because the judge had already found that the majority of the apps on the App Store were in fact third-party apps. And she held, and we don't quibble with this, that a consumer would not necessarily be particularly familiar with app stores or have any clear understanding that the majority of apps in the SGA store will originate from third parties unconnected with Samsung and not from Samsung, or as discussed below, from Swatch. That's not our point. Our point is not whether it's a majority or a minority. Our point is that an average consumer would understand that a significant proportion of apps on an app store were third party. Put it a slightly different way, an app store was a place where one would expect to find third-party apps in significant number, and that is the approach that the court should adopt in determining whether or not, presented with the material in question, the average consumer would think, my starting point is that this is going to be something to do with Samsung, or whether the starting point is, well, I need to look to see whether it may or may not be, but I certainly don't make the starting assumption that any app has got Samsung behind it, except in the very general sense of, they need to check that it's proper for its platform. So my point is not that the judge was wrong, but one needs to understand what the judge was saying in that context.
So the judge also identifies a different average consumer once the app has been downloaded.
Yes, and that's a point that I'll come on to in the last section, because that deals with the specific finding of the judge relating to the possibility that non-consumers may see the installed face on the watch of a consumer. Does that clarify?
Yes, it does. Thank you very much.
Anyway, if we then just briefly go back to 95 onwards, we've set out in our skeleton at some length why we say that some of these points really don't come into consideration. So, for example, taking it up at 95, she says many of the features referred to below, including but not limited to assistance designed to make it easier for app developers to create apps, providing an environment under which apps could be uploaded, stored, and downloaded, would not or would be unlikely to amount to use if taken in isolation. But that would not be the right approach. Instead, it must be correct to consider Samsung's conduct as a whole. And we respectfully submit that what the case law suggests is that what needs to be considered is the specific use of each specific mark to see whether that, in its relevant context, would signal to the average consumer that that product was connected with Samsung in the sense that it was one of Samsung's own proprietary apps, or whether the communication would say, actually, this is a third-party app. So our respectful submission is that that was the wrong starting point of perspective for this analysis. And she went on, initial overarching point relates to Samsung's watches themselves and the way they're marketed as truly watch-like, also by reference to the wide variety of apps, watch faces available in the SGA store. Well, that is neutral on this point. Indeed, the whole point about third-party apps is that they are there to adorn the relevant faces of Samsung smartwatches. That doesn't decide whether or not, or even is not relevant to whether or not this is regarded as, by the average consumer, as Samsung's apps or third-party apps. Of course, all of the apps in question are for that purpose. Next point, Samsung specifically advertises the availability of a wide range of apps in the store. It's a feature worth promoting, made a commercial choice to design only a limited number of watch face apps itself, and instead to allow and indeed encourage app developers to develop the vast majority. Again, if anything, that's a point going the other way, because insofar as it is saying the majority of the apps are third-party apps, and assume that that would be known to the average consumer, which the judge obviously doesn't say that would be known, but assume it were known to the average consumer, that would reinforce the average consumer's point that these were third-party apps and not Samsung apps. Indeed, what it would be saying is Samsung don't do their own designs of apps. They're all third-party, or substantially third-party apps. That's what you should expect. What Samsung is providing is a platform for third parties to undertake communications, if one uses the language of the case law, or a platform on which third parties can then put their own designs. It's like a kind of blank canvas on which artists can make their own designs. And then the next point, Mr. Lee's unchallenged evidence showed there are additional reasons why it's Samsung's commercial interest to host third-party apps, particularly free apps. It's desirable that they're developed and made available. Of course, any technology platform of any kind is going to have a commercial interest in its platform being used by third parties for software. I mean, that's what you have technology platforms for. It's no different from L'Oreal or eBay or any of these other platforms saying, well, yes, there's no commercial interest to have a platform that allows third parties to have products on the site. And she then goes on to say there's a symbiotic relationship between app developers and Samsung going well beyond revenue derived from the sale of apps. Again, not known to the average consumer. Obviously, the revenue is trivial. But again, let's suppose that there is a symbiotic relationship. There is a symbiotic relationship between eBay and those who use eBay, or Amazon and those who use Amazon to sell products as a third, insofar as they use it as third parties. That is the purpose of a platform. Platforms always have symbiotic relationships with those who are using them. That can't mean that this is a factor suggesting that it's the platform's own commercial communication, because otherwise there'd simply be no distinction. It would always be the platform's own commercial communication. The next point is related to that. Samsung provides material assistance to developers of watch face apps, hosts developers conferences, and so on. Yes, indeed it does. Well, so does any app developer. Doubtless, many platforms provide assistance of various kinds to enable people to get products and so forth onto a site. Again, it's got nothing to do with use of the trademark or the perception of an average consumer in relation to the products. It's a little bit like saying, well, because an art store which sells blank canvases and provides painting lessons helps people to learn to paint, that if they, let's say, have an exhibition or something of people who do that, then that will be regarded as their own commercial communication rather than that of people who've attended the painting lesson. Obviously, it wouldn't. It's the third parties who have been using these facilities, which were provided in a completely neutral way to all comers. Moreover, there's no evidence that any one of the app developers concerned in this case actually made use of any of these facilities. So it's not as though one can say, well, here is a situation where the facilities were made use of specifically in this case. Not so. Then, relevant that the SGA is a store that Samsung operates dedicated to apps of Samsung products. It reviews all apps for functionality and content. Again, this is, and that it may be able to download watch faces for Samsung smartwatches from other sites. And she says, I find the average consumer would understand that unlike watch faces in the SGA store, watch face apps available from other sites are not official and would not be understood to carry any assurance from Samsung that they would work satisfactorily on its products. Well, again, what we have here is not something that, first of all, would be known to the average consumer.
But she makes an express finding that the average consumer would understand that.
Well, in relation to that, we respectfully submit that.
So number one, she is looking at it from the perspective of the average consumer, yes?
On this aspect, yes, she is looking at it from the average consumer, but not on the other aspects.
And are you able to challenge the finding of fact, and if so, on what basis?
Well, what's said is that the average consumer would understand that unlike watch face apps in the SGA store, watch face apps available from other sites are not official.
And then she goes on to give the contrast.
I understand.
Apps available in the SGA store would be understood by the average consumer to be made available by Samsung, etc., etc.
Well, yes, but that might be said to be a conclusion. It's not a finding in the sense of fact. What it is saying is that is something that is attributed to the national average consumer. And indeed, in some sense, it is true in this sense that it does, to this extent, carry the assurance of Samsung that it will work with Samsung products, because in any context where there is some degree of content review, which there will be for app stores or for indeed any stores. And a consumer may think, well, if it's in the shop, it's had some kind of imprimatur from the proprietor of the shop. And we know from the other cases that that is an imprimatur that is to an extent provided by other online platforms. And the reason that it is because you can't operate an online platform unless you do a degree of filtering. So insofar as this is, that it's being said that because there is, to that extent, an element of filtering, the average consumer would suppose that it was a Samsung product as opposed to a third-party product that had, to that extent, received an element of filtering. We respectfully submit that that's simply not right. And the understanding of the average consumer is very important here, because it's perfectly possible for the average consumer to think, I know that this is a third-party product, but I nonetheless expect that the relevant retailer will have done some basic check for whether or not it is a satisfactory product. Just as in any other not online case, trying to think of other examples. Let's suppose that someone is providing beer in a bar or something like that, and one has to be careful with the various contexts of what may constitute use. But it might be that they will test a sample or whatever in order to check that it hasn't gone off. That doesn't mean that they're making their own commercial communication with respect to that product, or that the average consumer would think that. This is a finding about what the average consumer would think was a natural relationship in order to engage in some degree of basic filtering. And to that extent, we don't disagree with that, but that's not enough in our submission to make it Samsung's own commercial communication. So the next paragraph, 102, in contrast to apps that obviously relate to goods, third-party watch face apps do not do so, do not directly perform such function. Grouped together with watch face apps designed by Samsung, provide an optional alternative to the Samsung design watches preloaded on the watch. And again there, although they may be grouped together, all of these are grouped together. And in our respectful submission, that doesn't make any difference here, because the starting point for the average consumer approaching this would be that one would expect that a significant portion of them would be third-party apps. And then finally, function of the, nearly finally, function is not to provide third-party goods or services, but to adorn the watch. We agree, but again, that doesn't suggest that it is Samsung's own any more than a third-party design would be regarded as, any third-party design would be regarded as Samsung's own. The fact that it is a key part of the watch once installed, assume that's true, doesn't tell you anything about whether the average consumer would assume that it was a key part provided by or connected with Samsung, save in the very modest way of the review that I've indicated. Similarly, the other points, and the judge contrasted the position with the Uber situation. While the average consumer would understand that, say, the Uber app was provided by a third party and not by Samsung, not least because the app name will proclaim that, and it would be understood that the Uber app is available on multiple devices. It's much less clear in respect of watch face apps that are quite obviously designed to fit on function as key part of a Samsung smartwatch. Well, insofar as the relevant app name in question was evident, that was not an app name that was connecting the watch with Samsung. If anything, it was being connected with the watch brands in question, where the design in question was described using the relevant trademark. So the link there is not made with Samsung. Finally, the content review. She says it's linked to customer perception. The average consumer is unlikely to blame eBay for the shoddy goods acquired to its marketplace, but a poor quality watch face app designed for Samsung and acquired through the SGA store would reflect negatively on Samsung in the mind of a significant proportion. Well, it may do to this extent, and may do equally in the eBay context. If eBay is found to be selling, let's say, goods that have issues in relation to title or counterfeit goods and so forth, that could certainly affect eBay's reputation. And customers may blame it for saying, why didn't you filter this out? It's no different from the Samsung situation. And in our respectful submission, the fact that we did this filtering approach should be regarded as a credit rather than something that then saddled us with primary liability. On the CLG, well, I've looked at that briefly. The context there of valuable, entertaining, unique, and informative, and we can go to it if we need to, was one where the examples given were things that were really misleading the user. And what is wrong with saying that the apps in question should be designed to be apps that are aesthetically pleasing and don't make a mess of the screen and so forth. So in our respectful submission, while it is right that this is not a case that is on the same facts as Coty, and it is also right that Samsung, while providing the technical environment to allow the apps to be uploaded, it is also undertaking an element of principally legality review. The fact that it has a commercial interest in the watch face apps being in the store in general does not make these Samsung's own commercial communications. Samsung has no interest in having infringing apps on the store. Mm-hmm. Indeed, it has entered into warranties with the developers that they won't have put in infringing material on the store. I said this morning that Samsung does not care about these apps the apps in question being on the store, by which I meant as soon as the issue was raised, Samsung didn't quibble about this or say we'd like to retain these on the store for one reason or another. They removed them. And that, in my respectful submission, is if factors of this kind are relevant to whether or not something is Samsung's commercial communication, that is also relevant. The fact that Samsung distanced itself from that at the earliest possible opportunity when it was alerted. We say it isn't relevant.
I mean, the average consumer wouldn't know, and it would all happen after the average consumer had encountered the site.
I agree. My point is really that what the judge did was take into account factors of that kind in the earlier part of the discussion that we've just been looking at. They were of the same kind. If one's going down that route and saying all of that matters, then equally the counter factors matter. But our submission is that really, if one looks at this from the perspective of the average consumer, the right way to look at it is that these were apps which were identified as third-party apps. There was nothing to connect them specifically with Samsung other than that they featured on the SGA store. And this approach.
What this boils down to, I think, is that you say that from the perspective of the average consumer, that consumer would know or be taken to know that the apps in the store are third-party apps, and that Samsung is satisfied they will work on the Samsung smartphone, but no more.
Yes, and that's not enough to say that is Samsung's own commercial communication. So that really is the beginning and end of that point. I hope I've laboured somewhat the points where we say the judge took into account the wrong factors, because it's appropriate for making that submission to develop the point. Can I then finally deal with, unless my lords have questions on that, more questions on that point, can I finally come to the use in relation to what?
Yeah, now can I ask a basic question about this before you get into the detail? And I think we confirmed this earlier today, but just so as sure. As I understand it, the ambit of this ground of appeal is limited. You don't challenge the judge's conclusion that there is use in relation to the apps. You do challenge her conclusion that there's use in relation to the smartwatches.
Yes, that's it. And
so this is not a complete defence to infringement if successful. It reduces the ambit of infringement.
yes, and that's why I ordered the submissions in this way, my lord. The most important commercially first, then, as it were, the big point on non-infringement or non-primary liability, and then finally the ambit point. And can I just show my lords the relatively limited nature of the dispute and take that up with the judge's judgment so that my lords, my lady know where the argument is heading. You can take it up at paragraph 136. And I'd just like to identify the extent to which there is agreement on our part with the judge and the points which we say, at least for present purposes, we don't take issue with. The point that we take issue with is the tail end of this analysis. So starting at 136, signs have to be used in relation to the goods or services in question. Depends on how the average consumer would understand the marks to be used, taking into account the context. Take an example used by Mr. Justice Briggs. No one would suggest that using Pirelli trademarks on tyres amounted to use in relation to a Ford car to which they were affixed. And just pausing there, that is the one instance of a point that I mentioned earlier, where use of a mark on goods is not always use in relation to the goods on which it is used, and that specifically applies to goods which are composite in various ways. And the car example is one of composites, where you can say, well, the mark would be regarded as being used in relation to tyres, but not in relation to the gearbox. But in relation to content goods, by which I mean things that are not only physical articles or services, but goods which have a kind of either informational content or some other kind of content, there can be use on goods which doesn't amount to use in relation to those goods. And that quite often happens or may happen in the case of, for example, marks for printed matter and so forth, where you have got a mark for, let's take something completely fanciful, the Queen.
Well, I mean, just to take a more homely example, I think you would say that if I type out a judgment on Microsoft Office, I'm not using it in relation to my computer.
Yes, that's a very, I mean, there are many examples. The only point that it's just useful for you to have in mind is that there can be shades of complexity here, because there can be disputes over whether something is in fact used in relation to the whole. That can depend both on the presence of a mark on particular goods or particular position, and the absence sometimes of another mark or another indication on another part of the goods. So to follow this kind of example, if you have the mark Ford but no Pirelli mark on the tyres, some people might think, oh well, that's perhaps the tyres are forward as well, and then there may be counter indications. So each of these must be looked at quite subtly, and it's another reason.
It's a fact-sensitive question.
It is a fact-sensitive question, but what it does require is that those facts are properly evaluated, and in particular, if one is going to rely on what might be called well, perhaps extreme is not quite the right word. I was going to use that. A particular kind of alleged use, one has to be very clear what the basis is for that finding. That was just an aside, and I'm sorry if it's diverted a little bit, but it relates to a number of aspects in this case. So let's come back to the core point here. The judge refers correctly to Celine, include a situation where the sign is not affixed to goods, but a link is established between the sign and the goods, rather than, for example, a case where the use of a shop name is limited to identifying relevant business. Then the arguments are articulated, that we say there was no use in relation to smartwatches or watches, and that it was descriptive, and that argument was rejected. And then the judge makes the following evaluations. First of all, the average consumer would understand the use of a sign in an app name through the consumer's phone or watch to be used in relation to that app, and in particular what it will represent once downloaded. And she takes the Tissot example. Its use is in relation to the software, by which I mean the app, including in particular the watch face that the app will produce once downloaded. Same analysis must also apply to the preview, the watch face, to be viewed on the customer's phone or smartwatch before downloading, showed what the watch face would look like once the app is downloaded. And she rejects the other side's submission to the contrary. And
Can you help me? I didn't understand that sentence because it wasn't quite clear what she's rejecting there, because she seems to be agreeing with Swatch's case. She's saying that preview of the watch face is use.
yes, let me come back to that point. The only reason I'm hesitating on this is because there is an aspect of the respondent's notice that relates to preview, and our point on that is that the judge was right to reject that point, and partly because
But to be, maybe the answer is that what she is there rejecting is the last sentence of 138. So the preview, she says, is use in relation to the app, not use in relation to a watch.
yes, you may be right.
That's what I understood. Yes. It's disembodied.
Yes.
It's out there in the ether.
Well, I think it
hasn't got anywhere near the watch yet.
It's more specific. It hasn't gone anywhere near the watch. It's use in.
But it's on the watch.
No, that's the
no, it's not.
preview in the App Store, I think.
It's a preview in the App Store. Your Lordship, though, both your Lordships are right, in that it is both a preview in the App Store, and it may, depending on whether you download it via a watch, appear on the watch. But it may also appear on the phone.
141, she says, through a consumer, in the AJSA store, through a consumer's phone or
yes.
smartwatch.
Yes, that's
so what she's envisaging there, as I understand it, is that one of the things you can do with these smartwatches is you can scroll through the apps.
Yes, in fact, you can see it. We can go to it if we need to. You can scroll through the apps, and what you see is a really teeny example of the face next to the name.
Right.
At least if it's on the watch face.
And do I understand it correctly from the debate we've just had that therefore the judge's finding is that when you're doing that, you're scrolling through on the smartwatch itself. She says, yes, that's use in relation to the app, but even in those circumstances, it's not use in relation to the watch itself.
Yes, I think
what she's rejecting is that argument.
Yes, your Lordship is
That's
right.
What's being revived by the
Yes,
response.
I was just slightly thrown by this because I took my Lord's point that, and I thought actually perhaps that is slightly unusual, but that so understood, it makes sense. And I think that is actually the way
The
in which it has
distinction
been
she's
understood.
making is before and after download.
Exactly. And I'll just come on to that because it's the key, those are the key passages
Yeah.
that we come on to on the next page. So just basically 4 paragraphs. So the next point, she says, in reaching this conclusion, bear in mind the app payment preview would only be seen in a context where it would be obvious to the average consumer that the smartwatch app was just that, an app for a smartwatch, rather than as denoting the origin of the watch itself. And we respectfully submit that is exactly the right approach to take to this context, because what you're doing is, as it were, taking the perception of the notional consumer, imbuing the notional consumer with knowledge and reasonable circumspection relevant to viewing the relevant app, and concluding that the consumer would say that that is being used in relation to the app. And then we come on to the tail end issue. Once downloaded and used, the position is more complicated. And first you have this: the smartwatch owner knows that he or she is wearing a smartwatch and using an app. In contrast, a third party seeing the watch face may not do so. Now, the first point we agree with, and part of the reason we agree with it, or the first aspect, is because if one's postulating someone who's actually downloading an app, they are seeing the watch face in exactly the same context that they have just seen the app pictures. So they are not thinking, oh, this is anything to do with the underlying smartwatch. They couldn't think that because they know for sure that it's not true. That's the only way they can get it onto their watch is by having that knowledge. The point in issue is, in contrast, a third party seeing the watch may not do so. And she says, in my view, the dial branding, which appears is not used solely or even primarily to denote the origin of the app, although it does that as well for the consumer who is aware of what it is. That refers to the previous point. Rather, dial branding is intended to denote, or at least to appear to denote, the origin of the watch. And she refers to a number of cases on so-called post-sale confusion in support of that. And we respectfully submit that that point was where things fell into error, if we may respectfully say so.
You said earlier that these were the judge's evaluations. Would you accept that 145 is an evaluation?
It is an evaluation, but it takes place.
So would you accept you need to demonstrate an error of principle?
Well, I certainly accept that I need to show an error of principle. There's no doubt about that. And the error of principle that we identify is this: she thought that the approach to post-sale confusion, because she proceeded on the basis that the approach to post-sale confusion was such that a situation of this kind would fall within that kind of situation. And I just want briefly to explain why that was an error of principle. First,
sorry, could you say that again? Because I'm not sure I've understood the point you're making.
The basis upon which the judge made the evaluation that she did was that it is well established that the post-sale context is relevant. That's the principal basis.
So are you arguing that post-sale context is irrelevant? I mean, I can understand that as a submission, whether it's right or wrong is another matter, but is that what you're saying?
Our submission is that the post-sale context in this case, in this context, is irrelevant.
Sorry, let's start with the generality. You don't say that as a generality, post-sale is always irrelevant.
No,
right.
I don't.
So what differentiates this case from the general case?
There are two propositions that differentiate it from the general case. First, this is a situation in which the only way in which this kind of alleged confusion could arise is by a third party seeing something that the primary consumer could and would never be confused by. So this is not a situation typical of the post-sale confusion cases, such as, for example, data card, where my Lord, Lord Justice Arnold, held that because, for example, the mark remained on goods after they had been sold, it could therefore be seen by the actual consumer, real consumers. That meant that there was a realistic likelihood of confusion because the consumer may say, well, I'm going to order the same again and look at the product and take the mark off the product and order
The
the same
underlying
again.
thought is millennia old. So the oldest trademarks in the world are pottery marks, marks on the bottom of pots. And they're not put there to inform what you call the primary consumer, the purchaser of the pots, because the purchaser of the pots always knows from whom they are buying. The point is that a third party later in time, looking at that pot and saying, I think that's a jolly nice pot, who made it? And they turn it upside down and they look at the pottery mark and they find out who made it.
And there's nothing I can disagree with in what my Lord has said, of course. But this is a very different situation.
Well,
and that comes to
any different. If anybody looks at the smartwatch and sees the Tissot branding on it, which is there by virtue of the app, and they're asking themselves, who made that very nice watch? And what it tells them is it's Tissot.
Well, yes, that's possible. But let's take my Lord's example. And let's ask this question. Let's suppose in that ancient vase jug, there was some kind of cover for it, some other additional adornment for the jug, which was clearly branded as whatever it is. Let's not go too ancient. Hans Koper, recent, and on top of that, there was a knitted thing that was not Koper, but was something else. I can't at the moment think of a suitable textile designer of the same era to continue that analogy, but bear with me. In those circumstances, the temporary presence of a textile shroud around an otherwise correctly branded watch, visible momentarily, possibly on a bus by someone adjacent to the person in question, would, in our respectful submission, be a completely different situation from the one that my Lord has identified. What that would be saying is that not that post-sale confusion isn't relevant, but that the court should never look at the whole of the circumstances surrounding the likely encounter of a third party with that mark in order to determine whether it was realistic that the confusion in question would arise. Now, in this case, what we say is that the analysis that was undertaken requires a court to do a bit more work, if I may put it like that, when it comes to things like post-sale confusion. My Lord has given a judgment in another case that is not in the bundle, the Sazerac case, concerning the question of indirect confusion. And my Lord held in that case, it was concerned with drinks brands, that if one was advancing a case of indirect confusion, there had to be a sufficiently solid basis in evidence for a finding of that. One couldn't simply say, oh, well, there is some possibility. And our issue that we have with this approach to evaluation is that it does not do justice to actually the subtleties of the law that arise in a post-sale context. Just as in a pre-sale context, the court needs to look at what is realistically likely to going to happen, not least in order to fulfill its Celine duty of determining whether any use is materially likely to affect the functions of a trademark. And that simply hasn't been done here. What has been done is to say, well, there's case law indicating that post-sale confusion is to be taken into account, with no evaluation of the likelihood of this kind of scenario even occurring and causing any damage. So let me just make that point good very briefly. First, in the situation postulated by the judge, it would be equally obvious in our submission to the average consumer that the app in question was an app for a smartwatch. So the actual consumer, that's the starting point of the argument.
Well,
So
that's true of the buyer of the smartwatch,
Yes.
but the judge went out of her way to say the smartwatch looks like, if you forgive the expression, a real watch
Absolutely.
with its bezel and all the rest of it. So to the third party, it may look like a real,
Yes.
pardon the expression, a real watch.
Your Lordship is quite right, and perhaps it was unnecessary for me to repeat that point because that was just, in a sense, confirming what the starting point of the judge's argument. The second point, which, just to pick up on what my Lord said, is that the average consumer on this hypothesis would have to be someone who was a third party, who didn't have any knowledge of the installation of apps on smartwatches, and was sort of expecting to see, or perhaps neutral in this context, thinking, oh, if it's an adornment of that kind, it's likely to be something to do with the watch platform manufacturer, which would postulate someone who was thinking that for example, a screensaver, content on a screensaver, was likely to have some connection with the phone. Now, I don't want to be too extreme with this submission because there are obviously shades of understanding that people might have in the spectrum of consumers. But in order for someone to fall into this category of potentially confused, one would have to, as it were, exclude that category of those who were, of course someone does people do all sorts of designs for smartwatches. This is just one of those designs. It doesn't mean it's got anything to do with the underlying platform any more than seeing Coca-Cola or Pepsi-Cola, whatever, on someone's phone. They've decided to use it as a screensaver. You think, oh, well, that must have something to do with Apple. The second point is that one has to appreciate just how unrealistic the situation postulated by the judge was. The evidence in this case was that the screens turned off after a period, and that
there's an always-on function.
There is an always-on function.
So some people who are not so careful about their battery lives will have them always on.
Yes, but the always-on function actually didn't create, at least I'll be corrected on this, a app design that had the marks in question, because the thing about an always-on function is that it is largely black pixels.
Well, that seems a bit strange having regard to what the judge says at paragraph 45.
Well,
where she talks about the always-on display greatly adding to the device's real watch aesthetic. And so, if it has a real watch aesthetic with a round face, watch hand shadowing and ticking sound and so on, you hardly have, you cannot constant that if it's black the whole time.
I will check this, but if my Lord looks at paragraph 40, what the judge there finds, and I understand this to be correct because it's depicted in the material, if always-on feature is available and enabled, then a watch face will be displayed continually, although to preserve battery life and avoid screen damage, the version of the watch face shown would generally be a simpler version as compared to the one displayed while the smartwatch is in active use, using around 15% of the number of the pixels. That feature is not enabled. The watch face will change to a blank screen after a set number of seconds, the default being 15 seconds. So what one, and in fact there is in the bundles indication of the always-on display, which is different from the display, and in, I think, no cases, I might be wrong about that, but possibly very few cases, there's the trademark in issue at all, or if it does, it's in very much muted, almost invisible form, and one can see that in all the references to that, which is supplementary 18 to supplementary.
Which one?
It's in the supplementary bundle 1.
Which tab?
You can see a whole range of them. So there is, if you look at, for example, starting at 18.
So 19, we've got always on display on the right-hand side.
Yes, that's right. Which is a much darker version, and then 20, you see that doesn't have the mark. 21 looks like a darker version. 22, it just goes to much simpler design. 23, again, that's gone. There's no TISO. 24, no TISO in always on. I think we've got that in the next one. We do in 26, and then in 27, and then on the last one, 28, sorry, not the last one, 28, again, it's a very much diminished display, 29, diminished display, 30, equally, you might just be able to discern something, but it's very difficult. 31, again, 32. So there is a mixture, it's true, but always on, you shouldn't take from that always on means that the face is there and the mark is on, even in always on mode. In some cases, it's expressly off. And one has to actually actively set always on, of course, in order to get the effect. And it is perfectly obvious that if you set always on, even in, to that extent, always on, you're going to drain the battery much more quickly than you would be if you had a blank face. And so that's why the judge finds in paragraph 40 that if the feature isn't enabled, the watch face will be changed to a blank screen after a set number of seconds, the default being 15 seconds. So the overwhelming amount of time, unless a watch user is literally pressing their watch on again and again every 15 seconds when it goes off, or they select an always on display that results in the display of the mark in question, the mark will be completely invisible. And in our respectful submission, that's why there was no evidence that any third party, let alone anyone who may fall into the category of the relatively uninformed, had ever seen, could realistically ever see, even be in a position to see that display for the fraction of a time. Now, I accept that very possibly if you're sitting on a train next to someone and you might flick it on, then someone who might be looking in your direction momentarily and probably in breach of your confidence, bearing in mind this is an electronic input and output device as well, might see something at a distance from which they may not even be able to discern that there's any mark at all on the product. You've looked at some of the darker ones. It's actually very difficult, even blown up, it's quite difficult to see that there's any mark of any kind on the watch face, even if always on.
Is this a case-by-case assessment question? The reason I ask is I'm looking at page 42, which is the Galaxy example.
Yes.
Where the dial branding is clearly visible.
Yes.
On the AOD display.
Yes. Yes.
Right. So, do you say that that's not an infringement either?
Yes, I do on this basis. That even if it is visible when on, let me just get the relevant.
That's the always on. So what I'm trying to understand is if you're making a submission that there is never any infringement, and so far your argument has been, as I understand it, twofold. Firstly, you say that for most users it's only on for 15 seconds at a time. I get that point. And secondly, you say that for those users who choose the always on display, the image is blurred and frequently the trademark is not visible. And what I'm asking about is the second submission, where at any rate, as far as this is concerned, that doesn't seem to apply.
Yes. Let me just clarify the structure of the argument. The overall point is that there is no infringement on this basis at all, on the footing that the probability of a third party seeing this always on display, even taking this as the instance, the high point, is exceptionally low. And the reason is multiple. First, someone would have to specifically select always on. Second, someone would need to be in the category that I've identified in order for the relevant damage to occur. Third, they would have to actually be in a position to see this always on display at some distance that enabled them to discern that the trademark was being used, and to do so, fourth, in circumstances where, as with other characteristics of the screen, the trademark had been specifically dimmed to make it less visible even to the consumer. And the probability of all of those things happening, together with all of the underlying aspects, such as the watch needing to be in the right orientation, not under someone's arm, it is really a very remote prospect. But my lord is, of course, right to say that in principle, each of these marks has to be looked at, and each of these cases of infringement needs to be looked at individually. We say we've got an overriding point in relation to that, but insofar as there is reliance on always on, then for those that are not always on and display, that if they are always on, they're not displaying the trademark, the case simply falls apart. You can't have a situation where the 15 seconds of something coming up now and again would realistically be said to be viewable, or realistically said to damage the functions of these watch marks. My lady, that really is very remote. And if one then steps back from all of this and asks this question, can Samsung be sensibly be regarded as using these marks because some third party might see an always-on display of the Galaxy kind, which is the question that really is the underlying one. We respectfully submit that that is not realistic. None of the
I'm going to ask you about use by Samsung, because the judge has contrasted a before and after download position. And I was going to ask, is it accepted that after download there is still use by Samsung, if there was up to the point of download?
No, we do say that there is a potential for difference there. Our overriding point isn't used by Samsung at all. But
no, I follow that.
To say that there is
this argument assumes you lose.
Oh, indeed.
So let's assume, for the sake of this argument, that there is use by Samsung at least up to the point of download.
In that case, yes, we do say that it really is too extreme to attribute use by Samsung on the basis that this very remote possibility may occur in a third party viewing a display.
And why is that different from Pink emblazoning their T-shirts with the word Pink?
That's exactly the reason. Pink, the mark, was emblazoned on T-shirts in such a way that it was not only really unmistakable, that there was associated language which didn't dissociate itself. It would dissociate itself from the pink mark being having trademark significance. And the prospect there was of essentially many people walking around with the pink mark emblazoned on articles of clothing there for all to see. The mark, insofar as it attributed trademark significance, there all the time. I mean, that is it's not only a classic example of always on, it's a classic example of always in your face. I mean, it was like really very prominent. And so one can see that if one does a case-by-case analysis, one needs to look quite carefully. One's looking at confusion based on post-sale, what actually is happening. And we don't dispute the propositions in Datacard and Pink that this can be relevant. What we do take issue with is that it was of relevance in this case. So those really are our core submissions on that aspect, which brings me to a close, subject to being told. Oh, yes. I'm told that the judge found on this page 2 one that there was no infringement. I think in fact Galaxy might be. Anyway, it doesn't affect.
But you could make the same point.
Yes,
reference.
I was going to say it doesn't affect the underlying point that my lord was putting to me, but I don't want my lord to be left with. that
Oh,
impression.
page 36, which is Mega Studio Master, the same point.
Yes. Yes.
All right, well, thank you very much, Mr. Alexander.
Well, I'm sorry if I have trespassed on your patience too
No,
much.
no, not
They
at
were
all. Not at all.
slightly longer than anticipated.
Mr. Malnitz, do you want 5 minutes now?
Lord, I think I'll be more focused if I start tomorrow morning.
All right,
Should be
there's
fine.
enough time for you tomorrow?
I'm sure there will be.
All right. In that case, we will resume at 10:30 tomorrow.